All rise. All right, be seated, please. Good afternoon again. How are you? Good. Good. You're not getting irritated with me yet, are you? All right. A couple of things. First, let me ask you, have any of you seen or heard or learned anything about this case or the people and places involved in this case inadvertently or otherwise since we were last together, or quite frankly at all? No's from everyone. I am going to admonish you that I do expect some media attention to be out there sometime today, maybe because of the unusualness that we recessed in the middle of a trial. So I'm just going to ask you to be extra careful and please make every effort to not watch the media, watch the news media or channels that have the clips of what's coming up next, or any of the auditory news channels just about this case. Just be extra careful during the next day or so as it relates to that. All right? One further instruction before I do read you the preliminary instructions that I am required to do is you may notice that Mr. Whitehead is not present with us here in court today. As we discussed at length, though, during our jury selection, and we talked about at any or all or part of the proceedings of a trial. So while I know it's natural for you to wonder why he isn't here, it's not relevant to you as to why he's not here, as I talked about, and whether they prove that the defendant is the person that committed that crime. So the fact that he is or is not present, or may be present during the course of the proceedings, in sometimes and not in at other times, should have no impact at all on your deliberative process. Does everyone understand that? Yes. Does anyone believe that you are going to have a difficulty at all following that instruction? I know it's natural reaction to think something like, well, he doesn't even care if he's not here, but I can assure you that's not the situation that we're in now. So I don't want you to wonder or speculate at all regarding the reason that he is or is not present during these proceedings. Agreed? Agreed. All right, thank you. All right, let me read you these instructions. As you know, you've been selected and sworn as the jury to try this case of the state of Florida versus Xavier Whitehead. And this is a criminal case, as we discussed, and Mr. Whitehead is charged with 3 counts of murder in the first degree, 1 count of robbery with a firearm, 2 counts of armed burglary with the dwelling, 1 count of arson in the first degree, and 1 count of tampering with physical evidence. The definition or the elements of those crimes will be explained to you later during these proceedings. Again, it is your solemn responsibility to determine if the state has proved its accusation beyond a reasonable doubt against the defendant. Your verdict must be based solely on the evidence or lack of evidence and the law. In every criminal proceeding, again, as we have discussed, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is never permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand in his case must not influence your verdict in any manner whatsoever. The information or charging document that I read from to you yesterday is not evidence, and it's not to be considered by you as any proof of guilt. It is my responsibility to decide which law to determine what the true backward and distinct in that regard, and this is one of our fundamental principles of our system of justice. And started, both sides have an opportunity, if they wish to, evidence will show, but please listen carefully because their statements are intended to advise you of what to look for during presented. Witnesses will be evidence. After all evidence has been presented during the case, the lawyers again have an opportunity to address you in what's called final arguments. Same admonition, what the lawyers say is not evidence, but final arguments are intended on telling you how to apply the law to the facts that you've just heard. Explain the law to you at that time, and you'll each get after all closing arguments. Our attorneys here are trained in the rules made, and it's sustained by me or upheld. You shouldn't try to speculate on what the witness might have said had he or she been permitted to answer them. You should not form any definite or fixed opinion on the merits of this case until you've heard all the evidence, the instructions on the law, and the arguments of the lawyers. Until that time, you should not discuss the case among yourselves, and to keep you from coming to a final opinion about the case until you've heard all the evidence. Frankly, anything that's going on as it relates to here in the courtroom, thoughts and opinions about what's happening and what has happened during the course of the trial. We will take recesses, as you've seen already. You'll be permitted to go about your personal affairs during that time. Again, same admonitions apply. Please don't do any research, discuss anything about the trial, neighbors, what have you. And just we share a common lobby and even the downstairs lobby, so keep your juror badges on. In the case, we'll know to keep their distance from you. If you are ever placed in a position that you overhear people talking about the case, and somewhat, or quite frankly, even if they're not related to the case and are talking about it, please let one of our bailiffs know as soon as possible so he or she can not on vibrate, so when it goes off, it still annoys the person sitting next to you. So make sure that you do turn them on and off as you come in and out of the courtroom. This case must be decided by you only on the evidence presented in this trial, in your presence, in the presence of the juror. You must not do any investigating places mentioned in the trial or look at the internet or anywhere else discussed during the trial. This rule is supposed to read about what you're not to do, but I know you paid attention yesterday and you paid attention today, so I'm going to err on the side of caution. Blue course of the trial, and when we do, we try to do it up here at the bench so you don't have to needlessly traipse in, and we are being recorded. If you do hear what we're talking about, again, let the bailiff closest to you know that you can, so she will tell me to modify my volume accordingly. Note-taking. If you would like to take notes during your convenience, we have a couple of things about note-taking. They're for your use and your use alone if you choose to use them. They don't become a part of, I don't read them. My J assumed with note-taking. Stay on top of the proceedings if you are. Way more notes and more detail than everyone else. Of what usually between witnesses or at other times that's convenient for you and the parties to take a recess. So when I look over and say, is everyone okay, that's code for do you need a comfort break? And if you need one, you better nod vigorously or I will not take one. And if you think I'm never ever going to ask that question and you need a break, then feel very free to let the bailiff closest to you know, and she will interrupt me and I will try to take a break as soon as practical in the proceedings. We certainly all rather have you attentive and here present instead of wondering if that mean old judge is ever going to let us out of here to use the bathroom or get a drink of water or anything like that. So it happens all the time. Please, I know courtroom proceedings can tend to get sometimes long and you're sitting there and in the not most comfortable chairs on earth. So please, if you do need a stretch or comfort break during the course of the proceedings, don't hesitate in letting us know. Any logistical questions before we get started? Everybody's good to go? All right.